My lord, the charges were framed during the trial on two broad offences, Section 376 of IPC and Section 5 and 6 of the POSCO Act.
376 IPC
376 IPC
and
Section 5C
5C of the POSCO Act,
within
my lord.
brackets
376(1).
only a minute, sir. Sir, I'll say everything truthfully.
Hmm.
The charge is framed under 376. I'm, my lord, consciously making, my lord, my submissions, my lord. Now, when, my lord, the conviction is recorded, the conviction is on two counts. My lord, I can, my lord, just for easy reference, I have quoted, my lord, the relevant part of whatever I am relying upon. This is, my lord, the order of conviction in para 3. Please have a look, my lords.
paragraph 3.
Paragraph 3 of this note. This is my note. What are the infirmities in the impugn order, my lords?
In view of the
This is, my lord, the trial court's conviction in view of the
aforesaid discussion.
in view of the aforesaid discussion, I find that prosecution CBI has been able to prove the guilt of accused Kuldeep Singh so and so beyond a reasonable doubt, and therefore he is convicted under Section 376 IPC. Please mark this, and Section 5C and 6 of the POSCO Act. My lord, now I'm not touching, my lord, 4 because which I have said that there is a trial conducted. There is a finding recorded that the child was less than 16. My lord, to be precise, 15 years, 10 months and 13 days as, my lord, held by the trial court's order, and we will have to, my lord, as of date, go by what the trial court's factual finding is. My lord, the appeal is pending. Now, there is an order of conviction.
Against this conviction, appeal is pending.
Appeal is pending, my lords. So, right now, my lord, so far as the child...
Adding to your assistance,
Yes.
page number 211,
Yes.
when the sentence was pronounced, para number 13 and para number 14,
Yes, I'm grateful.
where 376 to I has been dealt with.
Correct. I'm grateful, my lord. I'm relying upon it, my lords. My lord, kindly see. Then, my lord, page 2, para 5. I'm grateful, my lord. At the time of sentencing on 20th December, the trial court convicted the accused under Section 376(2) of IPC in light of Section 376(2)I, which was undisputably on the statute book on the date of the offence. Now, my lord, what is that 376? My lord, before I take your lordship to this, my lord, 376 has two parts. 375 is definition of rape. He is convicted of rape. There is no doubt about it. 376(1) says that if you are convicted under 376(1), then the punishment would be minimum 10 years and maximum life. There is an aggravated form of rape. Lord, if someone who is in a dominant position...
There are 4 or 5 illustrations given.
Illustrations.
Like in police station, suppose it is.
A police station or someone who is a family member, who has a dominant position, etc.
Or in an institution, public institution.
Public institution, orphanage, etc. Lord, then the punishment is minimum 20 years, and it can go up to your biological life. Lord, I, subsection 2, subclause I says, commits rape on a woman when she is under 16 years of age. Then dominance not necessary, nothing is necessary. If she is 16 years or less, then it would fall under...
independently, it falls within the mischief of 376 to I.
And therefore, the punishment will be
20 years
minimum 20 years and maximum
can be
up to biological life.
That's it.
My lord, here the court, my lord, convicts him under 376 2I.
Assuming that the victim is not a minor, in a case where the victim is raped but not a minor, still the minimum sentence of 371 in any case will be there.
Will be life.
Will apply. That will be minimum 10 years. It can go up to 20 years.
Yes.
This is also minimum 10 years.
Life.
2 is also minimum 10 years, not 20.
Two is minimum 10, but what is
To
awarded
that
is,
extent, he is right. You are right.
Yes.
To that
yeah,
extent,
he's right.
To that extent, you are
10
right.
years.
The amended, he's right. As it stood then, now it is, my lord, amended that it should be minimum 20, but we are not concerned. Minimum 20 and it can go. Here, my lord, the court has said till your biological life.
Right, sir. The minimum point is the offence is committed on 4th of June 2017. This amendment has been brought subsequently
18.
on 21/4/2018.
18.
So on the date of commission of the offence, whatever the situation.
I was there.
I was there.
Yes.
Well, like when the I was there on that day, then it will be read as it is, whatever the situation.
Absolutely.
And when the suspension of sentence was directed, you directly come to the page. Come to the page number, para number 30.
Yeah.
Yes, my lord.
Come directly, we'll let you know this, brief it, everything.
My lord, page 215.
Yes. Then where they have only been dealt with, come to page number, internal page 37, para 30, last line. They have dealt with of 376(2)(b) without dealing with 376(2)(i). That is the crux of the matter.
Lord, as a matter of fact, your lordship comes to page 25, para 25 of the impugn order. My lord, please come to para 25 of the impugn order. My lord, that is more, my lord, erroneous. Page 30, my lord. Kindly, my lord, for my satisfaction, come to page, para 25, page 30.
Yes.
Para 25. The learned trial court has convicted the appellant for the offence under section 376(2) of IPC as well as section 5C punishable under section 6 of POSCO Act. For the purpose of present application, this court turns its focus to the appellant's conviction under the POSCO Act only. So 376, whether 1 or 2, it is life or biological life. That's the only distinction. But life is the minimum in the facts of the case. No, that's not considered.
Life
And
is not the minimum.
Only a minute, sir. And the court says, now 7 years, you are not a public servant. So you fall and, my lord, I have another argument, my lord, on POSCO Act also. Because my learned friend could argue on that.
Is it your argument that the concept of being a public servant
Yes.
is completely alien and irrelevant when the victim is a minor?
Absolutely. Now kindly, my lord, take the POSCO Act. Where, my lord, there is a legal what has gone wrong. Lord, please kindly have a look at, my lord, the POSCO Act. Lord, POSCO Act offences can be broadly classified in two categories. Broadly. One is penetrative sexual assault. It's per se an offence. Lord, section 3.
Section 3.
Section 3. Assault is an independent offence. Now 4 provides for the punishment. Lord, prior to the
Amendment.
amendment, my lord, which came after the offence was committed.
2019 amendment.
Yeah, yes, my lord, 2019. My lord, it was after the offence in, but my argument would be it doesn't make any difference. I'll come to that. It was, my lord, not less than 10 years and which can be life. Earlier it was 7 years. Now, my lord, there is a separate category of offence. The same offence, my lord, which is penetrative sexual assault, but in certain circumstances, it is aggravated form. Aggravated based upon the person who commits the offence. And if you go by, my lord, the nocitoro socis doctrine or, my lord, the egestem generis, my lord, the categories are that if a person is in a dominant position over the victim, then he is considered to be an aggravated form of offence. Please have a look, my lord. Whoever being a police officer commits penetrative sexual assault on a child within the limits of police station, in premises of any station house, in the course of his duties or otherwise, or where he is known as or identified as a police officer. My lord, kindly take an example of 5A3. In the course of his duty, a constable is a category, my lord, who, if commits an offence, would be in the aggravated form. Kindly bear that in mind. Then B, whoever being a member of the armed forces or security forces commits penetrative sexual assault on a child, my lord, the same. But 3, in the course of his duty. So if an SRP man is there, my lord, in the security of a member of parliament or a member of legislative assembly, he would be guilty of aggravated penetrative sexual assault. Now please see C. Whoever being a public servant commits penetrative sexual assault on a child. My lord, my respectful submission is, my lord, public servant is not defined in this act. It is, my lord, defined as borrowing, my lord, or definition by reference, that whatever is defined under the IPC would be the definition. But the important question of law would be section 2 starts with unless context otherwise requires. My lord, every word used in any statute is not mechanically getting the definition. If the contextualized definition is to be considered, then public servant would mean a person who is in such a dominant position over a child, because POSCO Lord, deals with only children.
So according to you, in the legislative intent, in a kind of a non-obstante clause in section 2 opening, where
Yes.
it says unless the context otherwise requires.
Yes.
The expression public servant is a very broader term.
Broader term.
Broader term. It's not necessarily for the purpose of public servant. Say you treat an PC Act or under
Or IPC.
IPC.
Yes.
Here, it public servant is that who is in a dominating position.
Yes.
In a particular factual background of a incident that is.
Particular case. In this case, he was MLA of that area, a
Okay.
very powerful MLA, and the girl
If a
was 15.
representative comes, if a public representative comes to MLA and seeks any kind of help, assistance for any, say, public duty, and there if he misuse that dominance of being a public representative, then this is your argument that such an act will fall within the ambit of
Public servant.
misconduct by the public servant.
Aggravated form of.
Aggravated form of.
No, otherwise, kindly see the incongruous position which arises. I am a member of parliament. My lord, I will have, my lord, one police constable as my security person. He would be a public servant for the purpose of, my lord, section 5. I will not be a public servant. Why? As per, my lord, the argument of the accused, because in A.R. Antule case, the Supreme Court has said that member of legislative assembly is not a public servant. But that was in a fact-specific situation. But what happened was, Mr. Antule was a chief minister when the offence was registered. So he was a public servant. Thereafter, he had to tender his resignation, and therefore he ceased to be a chief minister, but continued to be a member of legislative assembly. When the charges, where cognizance was being taken, he raised an issue that this is a offence under Prevention of Corruption Act 1947, which did not have the definition of public
servant.
And therefore, no cognizance can be taken against me
So
unless you have a sanction.
Exactly. So at that time, probably the member of the legislative assembly were not considered in public servant definition under
Yes.
the old act.
So the court, my lord, construed that provision in the context of Prevention of Corruption Act and against him, that no, you may not be a public servant. You are MLA and therefore you need not have a sanction and you can be proceeded. That law will not apply if we interpret this public servant.
See the relevance of the context otherwise required. There the court did not want to grant him the protection of not being a public servant for the purpose of prosecution under the PCA.
Exactly, PCA.
Therefore, court said,
Grateful.
even if you are not a public servant, you are still able to be prosecuted.
I'm grateful, my lord.
So that was in that
Yes,
context.
my lord. Now, my lord, my third submission. My lord, suppose he is not a public servant for the sake of argument, my lord. I presume he doesn't fall within 5C. He would definitely fall within 3. Because it is, my lord, it is a penetrative sexual assault. That is the finding recorded.
Minimum
Now-
7 to end life.
Yes.
Minimum 7 and life.
Now, my lord, 4. My lord, the argument is this, and kindly see, my lord, this is, my lord, the very nuanced argument which, my lord, I am placing for your lordship's consideration. When the offence was committed, penetrative sexual assault was an offence. I am on Article 20 argument. It was punishable by 7 years. Amendment does not create a new offence. It merely enhances the punishment. Instead of 7 years, now it is life. So when existence of an offence is not in dispute on the date on which the act under section 3 is committed, mere enhancement of sentence subsequently by the legislature would not fall foul of Article 20. There are judgments to that effect. You cannot have a new offence. The reason is this. when I am committing some act, but not any act, then I am presumed to know whether that act is illegal or legal. At the time when I commit that act, if that act is not an offense, then I cannot be punished. So new offense cannot be created retrospectively by the parliament or by the legislature.
Maybe that your argument probably it can be that there is an offense defined on a particular date when the incident takes place, occurrence takes place. That is, let us say in 2017.
Yes.
In 2019, when the amendment takes place, the amendment does not obliterate the offense. It does not erase the offense. The offense continues to be an offense.
Yes.
The legislature makes rather intention very clear that this offense we are treating very serious offense. It is offense against the very ethos of the society, and therefore we are enhancing the sentence. We are enhancing the sentence. So when the court is examining after somebody is held guilty, if he is found guilty, he is convicted.
Yes.
And when the question of sentencing comes, the court will see what is the growing trend. The growing trend is that the legislature wants it to be more harsher and want to send a kind of a very deterrent and a befitting response, keeping in view the very cruelty and the extreme
gruesomeness of the offenses.
The court, even under the old provision,
It was
when considering that whether it should be a case of minimum sentence or it should be more than minimum sentence.
But
So sentencing part, it
the
can be.
logic behind Article 20 is, well, not suppose I am committing an act today, any act, which is not a penal offense. I can say that, but I didn't know that this is an offense. Therefore, you cannot create a new offense. But when I am committing an act, it is an offense. Lord, can I say that I committed an act because I knew that it is only
It will
7
apply to
years?
reverse also. In a case, suppose there is an offense in 2017 and 19 legislature says it is no longer an offense.
Correct.
The court can keep in mind that he is guilty of a technical offense, which is today no longer an offense. Therefore, I should award him the minimum one. That
can be a consideration for sentencing.
Mitigating circumstance, one of the mitigating circumstances for the purpose of
Sentencing.
evaluating the quantum of
Punishment. I am grateful.
That is probably what.
Yes, my lord. And the last, see, my lord, section 42A of the POSCO Act. My lord, this is also not considered. The trial court considers this. My lord, there is an intrinsic guidance as to what happens, my lord, if there is any divergence between any other law and POSCO. 42A. My lord, I am in the context of, my lord, IPC definition and this definition, and we have to take contextual meaning of public servant under section 5C of POSCO. Lord, please see, act not in derogation of any other law. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. And please mark, in case of any inconsistency, the provisions of this act shall have overriding effect on the provisions of any such law to the extent of inconsistency. Lord, fortunately, Lord, this convict, Lord, is also held guilty of, Lord, killing the father and some other people, Lord, in a different offense.
There he has been
He is convicted
for part 2.
Yes, my lord. And he is still in jail, and therefore, Lord, in this impugned order, Lord, he has not been able to come out. So, my lord, this is an occasion where I would really, my lord, urge your lordship's conscience, my lord, to stay this order, my lord. We are answerable to the child, my lord, who was 15 years, 10 months.
Yes, what do you say, Mr. Harihan, Mr. Dave?
Yes. Now, my lord, can I? My friend, before my friend starts, your lordship may kindly see what was the charge.
What is your answer to para 25 and 26 of the High Court order, that where the High Court takes notice of the conviction under both IPC and POSCO, and then in para 26 the High Court inadvertently does not deal with the conviction under the IPC?
Just have 2 subsection 2 of POSCO for a moment. That has not been placed. 2 subsection 2. Please have that section.
Let us just read
2.
that for a moment.
There specifically it says, words and expressions used herein and not defined but defined in the Indian Penal Code, Code of Criminal Procedure.
No. Just
No, your lordship
section
says-
2.
Section 2, subsection 2. 2.
2.
2. After the
Huh?
definition,
Hmm.
please see, it's not that there is a vacuum.
The words and expressions used herein
Herein and not defined, but defined
in
in
IPC,
the Penal Code, Code of Criminal Procedure,
Hmm.
Juvenile Justice Act,
Hmm.
and Information Technology Act
Hmm.
shall have the meaning be respectively assigned to them in the said codes or the acts. So the High Court on Mr. Hariharan's argument, my lords, was that since IPC is specifically mentioned, 21 defines public servant. If 21 defines public servant, does not include
how
MLA.
does this subsection 2 answer the argument
For the
that when the conviction are two statutes, two different penal statutes,
sentences under
and the High Court only proceeds on the premise that sentence is under the POSCO only.
sentence.
No, no, no.
Conviction.
Can I?
Not only sentence, conviction.
Conviction is under two.
Huh.
You can't be sentenced under both, my lords, because of General Clauses Act, Section 2520.
That's
You
right.
can only be sentenced under one. Argument was, I'm sure my learned friend will be able to place it better than I can.
Hmm.
The argument was that, look, you are sentencing whether I'm a public servant or not. The meaning under the POSCO is you have to take that meaning from the Indian Penal Code. Now, this argument that MLA is a public servant in the larger picture and all that argument for us doesn't arise for consideration here because the statute itself provides that under 2.2 that the meaning will be taken from Indian Penal Code. And likewise, in Indian Penal Code, there is a section 7 which says words and expressions used herein at one place shall have the same meaning throughout the code. So it is too late in the day for my learned friend to contend that I am an MLA in the scheme that a public servant, and therefore, Mr. Hariharan argued that, lords, that this, when I can, you can.
The matter would
My lord,
require
my lord, can I put 2-3 propositions before my lord?
No, it
I
requires,
was
not just by consider.
consideration.
consideration.
The first proposition, my lord, which I am making
You
is,
can argue on the point of stay. We are tentatively, we are inclined to stay the order.
your lordship will kindly see, I have 2-3 things to say on that. If your lordship will just hear me,
Before
is
he
not
starts,
as if I have been
sentencing,
let free.
he is as of now.
I have, my friend, can I?
No,
You had-
sentence for life till you leave.
Can I have my say? This is,
General principle is that if someone has been released consequent upon an order of grant of bail, we will not stay that order without hearing the person because we can't take away, we can grant bail ex parte, but we can't set aside that order. But here the situation is altogether peculiar. He continues to be in custody on account of his conviction and sentence in another case where he is still there in custody.
my lord, can I?
Appeal has been heard and 10 years out of 10, 9 years I've undergone.
I have gone under, your lordship, for a minute, can I?
Examine that part.
Can
We
I-
are not
can-
saying- we
can
are
I
only
make my
saying that
submission?
matter requires consideration.
Can I make my submission, my lord? In relation to 2 or 3 things, my lord, we will have to revisit the order passed by the concerned court. If your lordship sees that, the court was conscious all the while in relation to all the provisions.
So
Number
the
one.
order
No, it
Number
is
2,
very clear.
Sir, Mr. Hariharan, this is
Please.
incorrect.
please, my lord.
Court is not non-vigilant to look into all the provisions. You will kindly consider the court has only dealt with whether he was a public servant or not. The court has not dealt with whether the offence with respect to 2I or not, 376 2I.
Can I will
Now, please
I will
kindly
answer.
tell us
I will
where
answer.
this has been considered.
I will answer, my lord.
Please
I will
answer.
answer. My first answer to this is that, my lord, the charges which were framed, the charges were framed under 376 clause 1. Your lordship will kindly see. I just show you that portion.
So this is not a ground of granting the suspension
No,
to you, sir.
that, my lord, I am saying that
This
there is
not
a
ground
charge
to
which
grant
has
the
been
suspension to
framed
you.
in relation to 376(1). I was to answer that charge.
The ground of
He-
granting the suspension was it doesn't fall within the definition of the public servant.
That is
And
the,
as per section 21.
as far as
And
public,
therefore this has been done.
my lord, can I for a minute expound on that aspect also?
Yes, sir, please.
The element in relation to the public servant aspect is, my lord, the first proposition is a penal statute cannot import definitions from another statute in the absence of
But we are
expressive.
going on that.
Unless
Please
the
kindly
penal
listen
statute,
for a
the
second,
the
sir.
law is, unless the penal statute expressly permits the borrowing of any such statement,
Yes.
Which it has
as
done.
it is done in the case of.
So here it is being done in relation to the Indian Penal Code, wherein the definition of public servant is to be imported from there. 21 does not give that scope.
Public servant, sir, public servant.
Your lordship will kindly see.
Mr. Hariharan, we crisp of everything. We are not dealing with their arguments at present.
Very good.
We are only saying it's a question of argument.
My lord,
Yes,
in
sir.
relation to
Please
that,
listen.
in relation to
For a
that,
second,
my lord,
sir,
We are only-
kindly for a second, we are crisping everything. Come to page 211.
my lord,
Trial court's order, suspension.
211.
The sentence
Yes, sir,
of order.
please.
13 is the submission.
13 and 14 is the submission answer.
Yes.
Please
13
kindly
is the
see.
submission.
This is relating to 376(2)(I),
2I.
where the punishment has been directed. And now please tell us in the suspension order where they have dealt with of 376(2)(I). This is the answer.
Please have 204 also at the same time. In the conviction order, please see what I'm convicted under generally 376.
Two.
Doesn't, 376.
No, 376.
Please see
Yes.
204.
So 376 will cover 1 and 2 both.
One and two both.
Can't be
The
the
charge
law.
is
That
under
can
one.
go in on merit. No, you
The
can't ask
charge
your
is under one.
sir.
Your lordship is
You
kind
can't
of
ask
see.
Mr. Dave. No, sir.
Your lordship
No.
are well aware,
Sir.
it has to specify if there are two provisions providing for two separate.
How can it be that it will be a generalized situation, my lord? It's a
Point is that there is a legal issue that requires determination. Maybe that your argument we don't say. Your argument has also a lot of weight that also requires in-depth consideration. Sometimes the to be very frank, the judges are one of the finest judges we have.
My lord, your lordship will kindly see that
Analytical mind.
there is a,
So far
is it a media trial, my lord?
have been dealt with. There is a very in-depth analytical analysis made as far as of various provisions. But at the same time, we all are bound to commit errors. It's not
And that's all right.
That is besides.
That's all right, my lord.
But photographs of the judges being circulated.
examining. We are
My lord, there is one more important aspect to this. I have,
Mr. Harian, this aspect of definition of public servant in the context of POSCO
Yes.
is little bit
my lord, I will address in relation to that, as far as contexts are concerned, I will address, my lord. I have 14 propositions in relation to this, which I will place one by one. All constitutional provisions. And retrospectivity also. My friend is completely mistaken there, because the retrospectivity aspect is that here what is happening is, my lord, a class of people are being,
We are only worried that a constable or a patwari, they will be public servant for the purpose of committing this offence, but a member of parliament or a legislative member of elected member of the state legislative assembly or legislative council, if this interpretation is construed to be correct, they will be exempted.
no, my lord, I will also deal with that proposition, because here there will be issues which will arise in relation to doctrine of separation of powers as well. Because as far as those persons which my friend has defined, those persons fall within the,
Separation of power is a
my friend.
constitutional doctrine,
No,
not in
can
a
I
criminal state.
can I put across the, can I,
Prime Minister
my
and
lord,
you
can
are
I,
saying-
can I make the proposition? Before that, my friend will take off. This is,
And
But kindly just
my lord, there are only two things which I want your lordship to appreciate apart from this.
issue notice returnable on so and so date. Issue notice returnable on so and so date.
For the victim.
It's all right.
Because I am a aviator, kindly, this is one half of the story.
Today we are not deciding the case.
Look, I am only saying that I may be allowed to intervene in this matter. One,
We will see.
Milods,
Have you applied for?
yes, I am a caveator, Milods. I am a caveator in this.
Maybe caveator have you applied for? Why can't you file your own appeal?
All right, I will apply, grant me liberty. That is one, Milods. Kindly.
You don't
kindly
require
hear-
any permission, you have a right to file appeal.
Milods, can I hear
You will read
my
the
lord?
provision of the
2
CRPC.
minutes, Milods.
My lord, there is
So
one,
that this is one half of the story. Milods,
We hear you, let the order go in
Yes,
now.
my lord,
will
can
you hear
I,
me?
my lord, can I just say one thing in relation to the stay? Only one thing, my lord, in relation to the stay.
We have heard briefly.
My lord,
At solicitation of India at a considerable length in support of this special petition filed by CBI. We have also heard learned senior counsels representing the respondent in bracket accused,
Convict.
convict. We find that the subject matter that there are various substantial questions of law which arise for consideration in this special petition. Then say issue notice returnable on so and so date. Who is the who are on your side?
my lord, can I,
Sudhir, my lords, PS Sudhir.
The counter affidavit can be filed within 4 weeks.
my lord, I have a proposition to make if your lordship will hear me out.
We can't decide the
No,
proposal.
no, I'm not on that. I'm not on those propositions.
Now we are.
I am making a submission, my lord. The submission is, my lord, if I am going to, in relation to the suspension part,
We are conscious of the fact that ordinarily when a convict has been released on bail, a convict or stroke under trial has been released on bail pursuant to an order passed by the trial court or the high court, such order shall not be stayed by this court.
Normally.
Uh,
Normally.
We have.
We have said ordinary,
That so.
will not be stayed by this court without hearing such person. Full stop. However, here are the peculiar facts and circumstances. Full stop. The respondent convict is also separately convicted and sentenced in a case under section 304 part 2, and we are informed by both sides that he is still in custody in that case.